Recorded Books presents The Collapse of Constitutional Remedies by Aziz Z. Narrated by Pete Bradbury. Introduction. A quote from Associate Justice Antonin Scalia. Mirol Federales. In the spring of 2020, two litigants seeking a remedy for a constitutional wrong arrived at the U.S. Supreme Court's bronze door. One succeeded, the other was turned away. The difference in outcomes embodies two trends: the current collapse of remedies against illegal state violence and a rising use of the Constitution for regressive deregulation. The first litigant, Selah Law, LLC, was a California law firm that hangs its shingle next door to the Orange County Assessor's Office. It offers advice to individuals on how to manage debts. Selah Law found itself in trouble when the Federal Consumer Finance Protection Bureau, CFPB, fingered it for charging clients illegal fees for debt-related services and then lying about those fees. Rather than fighting those allegations or complying with a bureau request for documents, Selah challenged the CFPB's constitutionality in federal court. It complained that the president didn't have enough control over the bureau's director to satisfy Article 2 of the Constitution. The lower courts considered and rejected this argument, so Selah Law appealed to the U.S. Supreme Court. The second case started in 2014. At the time, Alexander Baxter had been living homeless and on the street in Nashville, Tennessee. One day he was arrested by two police officers for trying to break into a home, allegedly trying to steal electronics. The officers cornered Baxter in a basement. He turned to face them and raised his hands high in the air. Rather than handcuffing or arresting him, the officers set a police dog on Baxter. The dog leaped and bit him, sending him to the hospital. Invoking a Civil War-era statute that allows individuals to sue officials for unconstitutional actions, Baxter filed a complaint asking for damages. The federal trial court and the Court of Appeals dismissed his case. They did so without even addressing the question of whether his constitutional rights had been violated. Rather, both applied a doctrine of qualified immunity. This rule barred any hearing unless Baxter could show not only that the officers had violated the Constitution, but also that they'd done so in an especially serious way. As 2020 began, Selah Law and Baxter both found themselves before the U.S. Supreme Court. Both asserted facially plausible constitutional claims. Both, though, had lost in the lower courts. That's where the similarities ended. Selah Law had its case heard on the merits and won. The court directly moved to the question of constitutionality, ignoring the procedural obstacles of the case. The decision in Selah Law versus CFPB didn't turn on whether the constitutional violation at issue was egregious. It didn't ask if Selah Law had been harmed by the alleged constitutional flaw or investigate whether Selah Law would have been treated differently if the president had greater control over the bureau. Instead, the court delivered a smarting rebuke to Congress. It then invalidated a section of the statute creating the CFPB, albeit not enough to hobble the bureau entirely. Baxter, in contrast, didn't get past the courthouse door. His petition to have the lower court decision reconsidered, filed by skilled lawyers at the ACLU, was turned aside without explanation. The lower court's ruling was left undisturbed. In the end, Baxter lost without any federal judge even looking at the question whether his constitutional rights had been violated. The Supreme Court declined to hear his case despite a slew of commentary from critics and justices, casting doubt on the wisdom of qualified immunity after the 2020 death of George Floyd in Minneapolis. Why the difference? The gap between Selah Law's and Alexander Baxter's fates turned on the availability of a remedy for a constitutional wrong. The Constitution contains many legal rules and rights. None enforces itself. Without a remedy, a right has no practical value. Remedies depend in the last instance on judicial action. Courts, that is, do not and cannot merely interpret the Constitution. If their work is to have practical value, they must also assign remedies in the form of damages, injunctions, or declarations as a way of giving practical effect to constitutional rights and rules. Congress might give courts remedial power to act, but at the end of the day, it is the courts and the courts alone that decide whether or not to use that power. This is a book about how and when we have remedies for constitutional wrong.
Sample complete. Ready to continue?